But look, let's frame the conversation around Hart's book. So how does law look similar to and different from orders backed by threats or the gunman model of law?
Right. So you're making reference to a guy named Herbert Hart, H.L.A. Hart. He was a British lawyer, and he went on to probably be one of the more famous professors of jurisprudence, legal philosophy. So, he was born, I think, 1907, and he became a barrister in London, and he had quite a successful commercial law practice. The Second World War came along, and he joined MI5. He was effectively a domestic spy. During the war, he had a pretty good war. And after the war, he didn't want to go back and be a lawyer. So he went back to Oxford as a philosophy don for, I think, 8 years. And then in 1953, having published basically nothing, but they knew he was really smart. He'd done really well in his undergraduate. They just gave him the chair of jurisprudence at Oxford. And that sort of old boys club has real problems, and often it misfires. But every once in a while, it really works. And they just knew this guy was good. And Hart went on to write in 1961 a book called The Concept of Law. He wrote it for his Oxford law class. It's on a compulsory jurisprudence course. And it has sold over 250,000 copies. And this is a book on legal philosophy. You can't actually believe that there is a book that is this well sold. And all Hart is doing, writing for undergraduate kids, there's almost no footnotes in the entire book. It's gone on to have 3 editions. All Hart says is, look, I'm going to look at how you can understand any legal system. So it's not just a nice Western legal, liberal democracy, it's anyone. And he says, there's 3 questions I want to answer. And the whole book is on these 3 questions. To what extent can you understand law as orders? The gunman model, you must do X. Mm-hmm. To what extent can you understand law as a system of rules? Hart's idea. And to what extent can we understand the legal rules, legal obligations as similar to and different from moral rules, moral obligations? And that's the book. And the last, chapters 8 and 9 are just about that last question. And it's a question that splits people. So one tradition that goes back to the great Catholic thinkers, Aquinas, Augustine. The idea is that to some extent you could hold human laws up against some sort of higher laws. And now obviously traditionally it was God-like laws, the laws that God infused into the fabric of the universe, but you don't need a God. It can be moral standards you can reason to, like Kant said, whatever. And to the extent that human laws are deficient, they don't really count as law, or they're suboptimal, or they're substandard, or they're sort of half-assed law. The other great tradition, it says, well, Stalinist Russia had law. It was just really bad law. And so it is law, and it still counts as law, even though it's terrible. And Hart was an exponent of that view, the second one. And his view was that you get better moral outcomes if people stand on one platform and they ask themselves, what is law? And they can look at the statutes and look at the case law. And then they get down and they walk over and they stand on another platform, the moral platform, and they say, is that law good or not? And it's, you can't look it up in a dictionary. Is it better to take a wide view where even wicked legal systems count as law, but then you go on and say, but they're really bad? Or is it better to say at some point law becomes so morally egregious it doesn't count as law at all? And there's no sort of dictionary way to resolve. It's a moral question.
Yeah.
And I think Hart's right in saying you end up with better consequences if people realize, law is one thing and morality is another. And sometimes, and Hart was pretty clear about this, you will be in a situation where you shouldn't obey the law. And so you said, yes, I know it's law, but it's not worth my obeying. And so that's Hart. Now, not everyone agrees with that. In a way, they sort of half agree with each other. It's almost a semantic argument about who gets to use the word law. But I think, that Hart book is an eye opener. It's a great book.
Because I want to stay on Hart's book. I really do, because I find this, it sounds obscure, but considering like these topics are really important now, because fundamentally what Hart was talking about was it was a discussion about the legitimacy of law, and not just the moral foundations and the reasoning, but the process as well. Because he had that discussion, as you pointed out before. It's like well, we can stick all this stuff in together, but there was a discussion around the moral foundations and the reasoning. He kind of said, well, that's not all that important. Let's just discuss about law generally. But it's still a discussion fundamentally about legitimacy. So,
I mean, Hart's hard-headed in a way. So, he was a Jew, and after the war, he got sent to Germany just before he left MI5. In fact, one of the first things he wrote was a little piece for the Economist, back when the Economist wasn't a woke left-wing rag.
Yeah. Back when the Economist actually cared about the economy.
Back when the Economist used to be worth reading. But so, Hart had basically a Churchillian view of the Nuremberg trials. So, when you're dealing with people who complied with Nazi law, and, they did some pretty morally distasteful things. Hart's basic line is to pretend that the Nazis didn't have a legal system. Hart's a Jew, remember? It's just wrong. They did have a legal system. It was a really bad legal system. And so when it comes to after the fact prosecuting the top Nazis, when they get up in court and say, well, we just were following orders, or we were just following the law at the time, Hart says what you're really dealing with is two moral questions. The moral distastefulness of retrospective law, passing a law that effectively says, well, you were following laws, but what you did was so wicked, we're going to hang you. And the moral distaste, so the moral distastefulness of a retrospective law against the moral distastefulness of killing 12 million people. And he said, that's really what's at stake. Now, it's much easier to sell what happened in terms of, well, the Nazis what their legal system was so awful, it didn't really count as law, but that's just not right. It's a way of selling it to the public. And I think Hart's right on that. So when you adopt the Hart approach, I mean, sometimes retrospective law is warranted, but not very often. So, the other comparison is maybe to the East German border guards. The East Germans would get these farm kids who had, they bring them and they put them on the Berlin Wall with somebody else they didn't know, and it could have been a secret sort of police person. They didn't know who they were with, and they were told they had to shoot the people who were trying to escape to the west. And after the wall came down, they prosecuted some of these border guards. And the question there on the Hart line is, when you weigh up the wickedness of what they did, which, we can all understand in a way, versus the retrospective law, you probably wouldn't prosecute those kids, especially when the West never went after the top East German leaders. And so Hart gives you a pretty hard-headed thing. You look at that, you're weighing up two evils. And when it comes to the top Nazis, of course you would prosecute them. Even when they come in and rightly say, I was just following law, well, too bad. That's not a good enough excuse to kill 12 million people. Right, or whatever, pick your favorite million number. So I like the Hart way, but the other way of looking at it is saying at some point, a legal system is so egregiously wicked, it doesn't count as law. And, that's easier to sell, but there's real problems with that.
Yeah.
You just have a hard time making tough distinctions. And the Hart way of looking at it,
that's a semantic argument. When it comes right down to it, that is a semantic argument.
God doesn't tell us the best way to understand the word L-A-W. You have to make a moral call, and people disagree. There's no obvious answer, but I prefer the Hart way of looking at it. I think it's better in a moral sense. You can have an aspirational view of law that it always is good, but that rules out 99% of the legal systems that have ever existed on Earth. If you look at the history of human life on Earth, most of the legal systems are pretty awful. They hammered women, they hammered people who didn't own property. Slavery existed throughout human existence until what? Until 150 years ago, the Catholic Church was in favor of slavery. So let's not beat around the bush here. So if you're going to take a view that only legal systems in the last 50 years count as law, you have a hard time dealing with most legal systems that have ever existed. And I think it's better to say, a lot of legal systems actually were law. They just were ones that we don't judge as very morally palatable. And
see, that's the whole thing about any retrospective law. Fundamentally, it's about the projection of morality and yourself back in time, forward in time, or across geographically. And I do have concerns about that. And that leads on to, one of Hart's argument that I kind of like. do legal rules and legal obligations look similar to and different from moral rules and obligations? And how so?
Yeah, so the Hart argument is basically that you can understand any legal system in terms of a system of rules. I didn't know I was going to be doing legal philosophy tonight, so that's pretty good. Um, uh, and so Hart says we live in a world of rules. And so if you imagine a big circle, it's the world of rules. They're not all legal rules. There's moral rules. There's rules that govern games. When you go and play pickup basketball, there's rules. You don't need a referee to play pickup basketball. There's rules of etiquette. And sometimes the most important rules in life are not legal rules. And Hart, goes on to tell us, how do you distinguish legal rules? And, Hart has a view that you look at what the officials in any legal system treat as a valid source of law. So it might be whatever Stalin says, it might be whatever comes out of a democratically elected legislature. You have to look and see, you don't know. But they're not always the most important rules. Moral rules, which they don't meet the legal test of, the moral rules don't come out of Canberra after 3 readings of a bill in royal assent. But sometimes they're more important. Sometimes rules of etiquette are important. I mean, I'm Canadian. I grew up where it's sort of changing in Canada, but I grew up where, my parents, if you didn't eat with a knife and fork, fork in the left hand, knife in the right hand, there was something, you just got in trouble. And yet there are 320 million Americans. And in the US, you cut, put down the knife, put the fork in your right hand, eat the piece of meat, put the fork back in the left hand, pick up the knife, or you cut up your entire bit of meat, the whole thing, put the knife down. And so Americans leave aside a small pocket and sort of Brahmins in Boston. They don't eat the way we do. And Canada is becoming more American on that. And, that's a rule of etiquette. There's nothing timeless about it. It's not that important. But when you watch, if you're Canadian like me and you watch Americans eat, it's really off-putting. What else can you say? It's not that hard to learn to use a knife and fork.
Well, Bertrand Russell discussed this in one of his books. He goes, "Why is there a rule that you can't eat peas off your knife?" Yeah. And he discussed how that actually led him into atheism and atheism into mathematics, because he was looking for an absolute.
When you go for say a Rhodes Scholarship or something, when you get down to the last few people, they want to know that you are able to eat properly, or and when you interview for some jobs where you're dealing with the public, you don't want someone who holds a fork in their fist like this, and people don't want to buy stuff from people who eat like that. And so rules of etiquette can be important. And in a sense, they're totally arbitrary, but they can matter. And, they're usually not that hard to comply with. Game rules, one of the insights Hart has is that if you look at a legal system through the eyes of a top court, so the High Court of Australia or the Canadian Supreme Court, these are people who are dealing with a normal high court, top court in a jurisdiction in the common law world. They might hear 60 or 70 cases. So 5 or 6 dozen cases. That's it. That's what they hear. If you live in a nice liberal democracy, the rules create a lot of certainty. And most people never see the inside of a courtroom. And I'm not talking criminal law. I'm talking, private law disputes. They never see the inside. You can lead a full life. You can make contracts. You can have a family trust. You can shape your expectations. You can have a wonderful life. And the rules create a really, a lot of certainty. And Hart says, this is the majesty of a well-run legal system. This is wonderful. And we spend all of our time at law school making students look at law through the eyes of a top judge who only sees the failures in the system. Hart says, these are the failures in the system. Now, they're inevitable. Humans are fallible beings. We use language, and it is inevitable when you lay down a rule, even a good rule. The best intentioned rule in the world will eventually run up against a set of facts where the rule doesn't really dictate an answer. Honest, well-meaning people will admit that the rule could go either way. Does it apply? Doesn't it apply? Does it mean the defendant wins or the plaintiff? And so in a way, judges have to make a call. But to see the entire legal system through the eyes of a top judge, says Hart, you're making a really big mistake. You're
Because
missing the fact that a legal system's majesty.
Exactly. Because you're always seeing the sorry, and I spoke over you there. Because you're always seeing, like, because we live in a world of I before E, but they only see except after C.
Yeah.
And fundamentally, that's the kind of world that they live in.